Good evening and welcome to this channel. Today we'll be delving into the facts about Nnamdi Kanu's case and whether he has case to answer. So this is merely presenting the facts to you and presenting the legal framework behind the facts. So, we know that Kanu was arrested in Nigeria in 2015 on charges of treasonable felony and related offences. After being on bail, he reportedly fled the country in 2017. In 2021, he was brought back to Nigeria after being in Kenya to face further charges. The prosecution later amended and expanded the charges. They now include terrorism-related offences, membership of a prescribed organization, broadcast of falsehood, etc., in the Federal High Court in Abuja. Some of this legal team have argued that the way he was repatriated or extradited renders the trial procedure flawed. In 2025, a court ruled that the prosecution had made out a prima facie case against him, that is, sufficient evidence to require him to enter his defense. Separately, courts have found that certain exhibits against him were inadmissible because of legal/procedural defects. For example, statements taken when his lawyer was not present. So, what is the prosecution's position and why the case continues? So, the court found that the evidence tendered by the prosecution raised serious allegations of Kanu's involvement in terrorism-related activities, and so the case must go to defense. The prosecution claims he made inflammatory broadcasts, incited violence, issued sit-at-home orders in the southeast of Nigeria, and belongs to the banned IPOB. The court emphasized that prima facie case simply means there is enough to continue. It is not a finding of guilt. So what is the argument of the defense? Why did the defense say he has no case to answer? So here we're going to see some of the key legal and procedural arguments advanced by Kanu's side. One is jurisdiction. They argue that since he was brought from Kenya, or arguably abducted, or extra-legally transferred, the Nigerian court may lack proper jurisdiction. Two is the doctrine of specialty, or the extradition law. Under the Nigerian Extradition Act and common law doctrine of specialty, someone surrendered from another country can only be tried for the offense for which they were surrendered. The defense says that the rule has been violated. New terrorism charges, 14 counts, were brought though the original surrender was for other offenses, which were 4 counts. 3. Inadmissible evidence. They secured a decision where certain exhibits were struck out because statements were taken when his lawyers were not present. This weakens the prosecution's evidence. Lastly, fundamental rights violations. They argue that the rights to fair hearing, proper counsel, access were compromised, which could invalidate the trial. So, why some say he has no case to answer? So, putting the defense arguments together, the claim no case to answer hinges on these points. One, if the court lacked jurisdiction, or the extradition or rendition process was unlawful, then the entire trial might be invalid. Defense points to the 2022 Court of Appeal decision that dismissed charges on jurisdiction and abduction grounds. If the prosecution's evidence is partly inadmissible due to how it was obtained, then the risk is the case is weakened to the point the defendant argues there is effectively no case or sufficient foundation to proceed. Next, if procedural or fundamental rights breaches exist, example, denial of proper legal representation, then the trial may be unfair and might be challenged as null and void. Next, the doctrine or speciality or extradition means that new charges might be invalid if they fall outside what was agreed with the surrendering country. The defense says this point alone should bar the multiple counts of terrorism now being pursued. But important to note is that the court has ruled otherwise. So, as noted, the Federal High Court in Abuja rejected his no submission case on 26th/27th of September 2025 and held that the prosecution has established a prima facie case requiring him to enter his defense. That means, at least currently, the court has decided that he does have a case to answer in a legal sense. Though, case to answer doesn't mean guilt, only that a trial continues. So, even though the defense says no case, the court has said you must answer the case. So, to summarize, yes, Kanu's defense has strong arguments about jurisdiction, extradition law, admissibility of evidence, and rights violation. No, at present, the court has not accepted the argument that he has no case to answer. It has ordered that he must enter his defense, meaning the case stands. Has no case to answer is therefore not the current legal status according to court rulings, though the defense is fighting hard on that basis. The situation is legally complex and politically charged, I must say. The outcome may hinge on procedural or constitutional law more than just facts of what happened. So, what happens if Nnamdi Kanu refuses to defend himself? Will the judge proceed with judgment? This has been the question many has been asking today. So let's delve into the details. What is the legal position under Nigerian criminal procedure? When a court rules that the prosecution has established a prima facie case, that is, there is enough evidence to require a defense, the next step is for the defendant to open his defense, either by testifying personally, calling witnesses, or submitting documents. If the defendant refuses to do any of these, Nigerian law provides clear guidance. What are the relevant laws? Section 303 and 309 of the Administration of Criminal Justice Act 2015. This governs federal criminal trial. So section 303 subsection 1 says, after the court rules that there is a case to answer, it shall call on the defendant to enter his defense. Section 303 subsection 4 says that if the defendant refuses to give evidence or call any witness, the court may proceed to consider the case on the evidence before it. In short, if Kanu refuses to defend himself, the judge will not stop the trial. Instead, the judge will close the defense case and move straight to judgment based only on the prosecution's evidence. 2. Consequence of refusal. If he continues to refuse, the judge has two options. 1. Deem the defense case closed, since he voluntarily chose not to testify or call witnesses. 2. Deliver judgment based only on what the prosecution has already presented. That means if the prosecution's evidence as it stands is strong enough to prove guilt beyond reasonable doubt, he could be convicted. If the prosecution's evidence is insufficient or unreliable, he could be acquitted even without presenting a defense. So his silence doesn't automatically mean guilt, but it's risky because the court won't have his side of the story on record. So, what is the judge's likely approach in practice? Given that this is a high-profile terrorism case, the judge will probably formally record his refusal to enter a defense. You see, that was the reason why the judge said he should write it officially and submit. To allow his lawyers to make a final written address, closing arguments. 3. Then fix a date for judgment. So this process ensures procedural fairness. The court must still evaluate whether the prosecution's evidence alone proves guilt beyond reasonable doubt. So, you see, Kanu's refusal is likely a political or a legal protest, not a legal strategy. He and his lawyers argue that the trial itself is illegal due to his alleged unlawful rendition from Kenya. So by refusing to defend, he is essentially saying, I don't recognize this court's jurisdiction, so I won't participate. But legally, the court still has power to proceed and decide the case. Thank you for listening.